In this study, I will be analyzing the quality of the news coverage towards the 2010 Supreme Court case of Snyder v. Phelps. The Snyder v. Phelps case is a landmark case for the First Amendment speech. To best understand the quality of the reporting, first discussing what really happened now that 10 years have passed since the case was first granted. According to oyas.com, a reliable Supreme Court database, the story behind the case is that when Marine Lance Corporal Matthew Snyder died, his funeral service was picketed by the members of the Westboro Baptist Church. The family of the Lance Corporal filed a lawsuit against the religious protesters on the invasion of privacy, intentional infliction of emotional distress, and defamation. U.S. District Judge Richard Bennett rewarded the Snyder family with $5 million in damages. However, the Fourth Circuit of Appeals held that the action from the Judge Bennett violated the First Amendment. The specific claim that the defendant stated was that it violated the protections towards religious expression. However, defamatory the content of the posters that the protesters were holding, their speech would still be protected. The question being argued was whether the First Amendment protected protesters at a funeral from liability for intentional infliction of emotional distress towards the family of the deceased. The facts include Albert Snyder, the father of Matthew Snyder, the Marine that was killed in Iraq, was planning to bury his son. Albert Snyder planned to bury his son in Westminster, Maryland. A notice of the funeral was provided in the local newspaper from which the Westboro Church heard of the announcement. The members of the church picketed near the funeral. They all followed the legal guidelines for a proper picketing. After the funeral, Albert Snyder filed a lawsuit against the church. A couple of claims were issued, but the one that the Supreme Court focused the most on was the intentional infliction of emotional distress. Was picketing, no matter how distasteful, protected under the First Amendment? Ultimately, yes. The court found that picketing of the Westboro Baptist Church was protected under the First Amendment. The court decided whether speech is of public or private concern requires us to examine the content, form, and context of that speech. Speech on public issues occupies the highest rung of the hierarchy of First Amendment values and is entitled to special protection. Not all speech is of equal First Amendment importance, however, and where matters of purely private significance are at issue, First Amendment protections are often less rigorous. If it could be considered by the public as a political, social, or other concern to the community, or that it would have a general interest to the public, then it would classify as free speech. The dissenting opinion was delivered by Justice Alito. He believed that Westboro fell under the protection of the First Amendment. He didn't believe that Westboro fell under the protection of the First Amendment. According to the website Justia Law, a Supreme Court resource center, Alito stated, "Our profound national commitment to free and open debate is not a license for the vicious verbal assault that occurred in this case." Now that there is a clear understanding on the background of the case, it's time to discuss the reporting that was conducted. The Time article, "Why the Supreme Court Ruled for Westboro" by Sean Gregory, that was published on March 3rd, 2011, does a great job reporting the case. However, some aspects from the report seem to be more of an accommodation for the reader than the truth of the information. There was a sense of making the audience feel for Albert Snyder's goal, such as The quote, such as the quote, "It's easy for 8 justices to sit up there and take away your privacy rights when they never have to worry about that. And now Westboro can pretty much do and say and act however they wanted. And there's not a damn thing anybody can do." By Gregory. When including this comment from Albert Snyder, the writer successfully appeals to the public's sense of empathy. This article does name and identify the case. The case also does a great job in discussing the history of the case and its build up to the Supreme Court level. The article also states uh, what states the case's history. What's important about this magazine news report is that this was the fourth article from this publication on the topic. Time magazine had a total of 4 news articles related to the case. The article did an excellent job in discussing the majority opinion. Gregory quoted the Chief Justice John Roberts. Whether the First Amendment prohibits holding Westboro liable for its speech in this case turns largely on whether that speech is of public or private concern, and this was a specific case that the judges determined the words on Westboro signs indeed dealt with matters of public import and are thus protected by the First Amendment. In the court's view, the signs highlighted issues like the political and moral conduct of the United States and its citizens, the fate of our nation, homosexuality in the military, and scandals involving the Catholic clergy. Showing the key results are important when identifying the quality of a news report. The article also mentioned the dissenting opinion. The dissenting opinion about Justice Samuel Allori wrote a passionate dissent. Respondents' outrageous conduct caused petitioners great injury, and the court now compounds that injury by depriving petitioner of a judgment that acknowledges the wrong he suffered in order to have a society in which public issues can be openly and vigorously debated. It is not necessarily to allow the brutalization of innocent victims like petitioners. I therefore respectfully dissent. However, a point that this article didn't do well was to properly identify the concurring opinion. They mention a broad term such as the court, but didn't properly identify who the justice who delivered the concurring opinion was. As quoted, the court also rejected Snyder's intrusion upon seclusion claim. The court. Again, the court. The coverage seemed biased in favor of Snyder, and the only commentaries were quotes from the justices, Snyder, and the members of the Westboro Baptist Church. The report gave a tone of disagreement with the court's decision. Gregory used pathos to make the readers pity Snyder and were critical of the court's ruling about the overall trust and dominant theme of the protests, which spoke to broader public issues. The Time magazine will be compared to a media standard, the New York Times. The New York Times has a total of 7 articles based on the coverage of the Supreme Court case Snyder v. Phelps. The article that published the results was titled "Justices Rule for Protesters at Military Funerals" by Adam Liptak. The article was so well written and covered that it filled out the checklist. The article named and identified the case. It discussed the proceedings of the case and its history. The vote in the court was discussed. The article mentioned the majority concurring and dissenting opinions. The article mentioned the statutes and applied to the case. And finally, the article mentioned the impact of the decision and the public reaction towards the decision. Now, diving in deeper and showing how LibTac fit all the criteria of having a high quality news coverage story. The majority opinion was mentioned. Westborough's choice added to Mr. Snyder's already incalculable grief, and emphasized that the ruling was narrow and limited to the kinds of protests staged by the church. Westboro funeral picketing is certainly hurtful, and its contribution to public discourse may be negligible. Justice Roberts concluded, but Westboro addressed matters of public import on public property in a peaceful manner, in full compliance with the guidance of local officials. The New York Times article mentioned the dissenting opinion of Justice Alito. In his dissent, Justice Alito said said such laws offer insufficient protection. The verbal attacks that severely wounded quote the verbal attacks that severely wounded petitioners in this case, he wrote, complied with the new Maryland law regulating funeral picketings. This article holds an unbiased tone of just fact reporting. There's no means to entertain the audience, only the news that occurred that's important for society. The New York Times is highly esteemed for its high quality news writing, and this article does not steer away from that quality. Finally, if these articles were to have been graded on the quality of news coverage, the highest quality paper would have gone to the New York Times. The New York Times would have received a traditional letter grade of an A for their work. Not an A plus like it says on the screen, but an A. They held their standards in coverage at a high pedestal and filled out most, if not all, of the points of coverage for Supreme Court cases results. Now, for the Time article, the traditional letter grade that I would have granted them upon would have been a B. They filed they filled a multitude of information towards the case, but it had a strong sense of writing for an audience emotional response. The Times article the Time article filled most but not all the requirements of having a well covered news article. The article would have been well covered if they had a more just the facts reporting and included the concurring opinion of the case. This study proves that not all information will be delivered in a news story when it comes to reporting on the Supreme Court decisions. If information is being held from Supreme Court by the news media, then it begs the question on what other information is being held back as well. Thank you very much.